suffered while under the employment of the defendant on the 12th of February 2016.
Yes. Yes.
My Lord, specifically, he claims as a result of that injury, he has been permanently incapacitated, and as such, is entitled to a whooping sum of $1,737,760. A lot of the records of the court will show clearly
Yes.
that in ventilating this claim, the defendant presented 4 different sets of pleadings to this court by way of amendment. After the original complaint was filed and the statement of facts were filed, the Lordship would find that they amended their claim 4 times, my Lord. A significant number of amendments. My Lord, your Lordship would find, based on our submissions, that those amendments were made consistently with the mindset to keep changing the narration in order to sustain the untenable claim which the claimant has filed. The injury which he claimed to have suffered, sir, is to his right eye, permanent blindness, as a result of an injury which was sustained on board a vessel owned by the defendant. My Lord, the records clearly show that the injury was actually to his left eye, and that eye has no problems even as we speak. The eye, which was which is the claim, which is based on, is an eye that was plagued with serious problems prior to the accident. My Lord, I would most respectfully urge your Lordship, because our written address is quite clear, and to save time, I would only refer to what I think is most important, is your Lordship to look at the pattern of lies from the very first statement of facts.
Yes.
Initially,
yes, my Lord.
My Lord. He initially denied that he had ever had any problems with that eye. It was only when we confronted them with the statement of defense that that eye, not only was that eye plagued with problems, it was plagued with serious problems which required cataract removal, and even so that he had to replace the lens in that eye with an artificial eye. Having seen that the defense had cut them out, they now amended their claim and kept amending it, changing the nature of their narration. But your record will also show that we have established that this claimant, as a witness, had an history of lying and making false claims. The record shows that he forged documents.
Mr. Olabi, I'm sure you have all these submissions in your.
My Lord, they're all in our address, my Lord. They're all there, my Lord.
Yes, I'll look at them.
Very well, my Lord. My Lord, in closing out, my Lord. My Lord, in closing out, my Lord.
Before the
well, my Lord. Just finally, my Lord, on the reply, my Lord, we respectfully urge your Lordship to take note of the submissions made in our reply, which clearly shows that the final address filed by counsel to the claimant is replete with all manners of opinion, which do not relate to evidence which was presented during the course of trial. A lot of the courts have since established in a plethora of authorities that a final address or an address is not a substitute for evidence. You cannot make conjecture and begin to make conclusions that do not flow from evidence that was led during the course of trial. My Lord, in closing, I urge your Lordship,
Mr. Olabi, Yes,
Yes, my
Mr.
lord, sir.
Olabi, the address
Yes, my
cannot
lord.
take the place of evidence and plead.
Yes,
So
ma.
that is right. Just
Yes, ma.
round up so
My lord,
that Jamie
I thank your lordship for the time accorded us. I mostly humbly urge your lordship to dismiss this claim
Thank you.
as it lacks any form of merit. The defendant, during the course of trial, sir, repeatedly said that he can still dive and that being blind in one eye does not stop him from diving. So his claim for permanent incapacity cannot fly, sir. He repeatedly stated that based on their regulations, their profession, he can dive with one eye. So even if he has lost
Yes,
one
sir.
eye, which is not attributable to our fault, he is not permanently incapacitated, sir. That's our respectful submission. I thank your lordship for the grace accorded me. I'm grateful, sir.
You're welcome. Thank you. Yes, Mr. Emmanuel.
Yes, my lord. My lord, in response to...
Yes, Mr. Emmanuel, can you hear me?
Can my lord hear me?
We
All
can
right.
hear you.
Yes, go on.
Can my lord hear me? All right. My lord, I said in response to the defendant's final written address, we also filed the claimant's final written address on the 22nd day of October 2025. As our oral argument before this honorable court. And we urge this honorable court to grant all our reliefs as contained in our claim. If my lord is pleased, I would like to, in few minutes, also adumbrate, if my lord is pleased.
Go ahead. I gave them the opportunity to adumbrate, so the same has to be given to you.
As court pleases.
Yes,
My
let
lord,
me hear you.
it's on record that the claim of the claimant is as to the fact that he had an accident while working with the defendant. And in the course of the accident, his face was impacted. He had a laceration on the left eye, and after examination was conducted several years after, which result was from the defendant's retained hospital, it was shown that the right eye now has an impediment, which was glaucoma. And the doctor from the defendant's hospital also confirmed that that thing that affected the claimant's eye, is as a result of the accident. There was no argument by the defendant on this issue. The defendant fielded two witnesses. The first witness, the defense of the defendant was that the claimant already had the surgery and that he lost the right eye as a result of complication from the right eye. As a result of that complication of the surgery, there is no way throughout the evidence of the defendant, there was no time that the witnesses of the defendant made reference to surgery as a result of the loss of eye. There was no time. In fact, the position of DW2 was that if not for the fact that the claimant was not religious about his drugs and consistency with visiting the doctor, that he would not have lost that eyes. So we are saying that there was no evidence that supports the defense of the defendant. No evidence. And there are a plethora of evidence before this honorable court by the witnesses
Yes,
the claimant court and even that of the defendant, confirming that the loss of eye, the loss of the right eye of the claimant was as a result of that accident. There was no argument as to the fact that I cross-examined DW1, and she confirmed that the claimant did a wholesome body examination, including his eyes. And there is nothing on record to show that he had ever had any issue with his eye apart from the surgery he had before his employment, which, my lord,
Yes,
the defendant
Mr.
counsel.
Emmanuel, I will look at the court record. The evidence is before me,
Yes, my lord. No,
and I will
my
look
lord,
at the
the
evidence
defendant
and the
counsel said something that I need
specific
to
proof.
correct. The defendant counsel said something that I need to correct. The defendant counsel said that the claimant has an artificial eyes. It's not true, sir. It's not true. He had a surgery on his eyes. The lens was
Mr.
removed. He had
Emmanuel,
artificial ocular lens, not
there is
eyes.
nothing you people will say here that will change the evidence on record.
As the court pleases. As the court pleases. So we urge this honorable
Mr.
court.
Emmanuel, there is nothing
Yes, my
people
lord,
will say here that will change the evidence on record. I have my records.
I agree with the
I
honorable
thought
court.
your
I agree with the
processes.
court.
Let me go and look at the records and give my decision. Yes,
As the court
is that all?
pleases. My lord, we urge this honorable court to grant all the reliefs of the claimant, holding that the claimant has proven his case with preponderance of evidence. I will urge, my lord, to discountenance all the defense of the defendant in granting same. May this honorable court be pleased.
Thank you. Yes, the judgment is reserved and date shall be communicated to the parties.
As the court pleases.
Hello, we're very grateful, sir. Thank you.
My lord, on part of the claimants, we are most grateful for the indulgence.
All right. Well, thank you.
May this court be pleased. Yes. Mr. Olabi, it's good to see you.
Thank you.
Same here, Mr. Ibrunke.
Yes, sir.
Mr. Ibrunke, the matter has been adjourned. You can leave now.
Same to you, sir.
You should go now. Why you go and entertain your client? You don't want to leave my lord and myself alone here.
Go now.
I'm waiting for my lord to say we can go.
Very well.
Yeah, they're adjourned, so I'm thinking we can leave. My lord, may I seek the permission of the court to exit the room, sir?
I think his mic is even muted.
I think we can go. Since he has said that judgment is done. Have a great week, sir. Bye-bye.
You too, sir. Now I can leave.